Welcome, debtors and borrowers, to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a bankruptcy and student loan relief attorney, and today we're doing fast answers. And the question is, what's the difference between a cosigner and a guarantor on a loan? So a cosigner is a co-borrower of the debt. All right, so there's really no distinction between the primary borrower and the cosigner. The key point is that a cosigner's liability on the debt is triggered as soon as they sign the paperwork, or as soon as however they authorize the loan. Whenever they sign, they are a co-borrower. So that means the debt will be reported on their credit report, just as it is on the primary borrower. If the primary borrower misses a payment, they can collect from the cosigner. So you are on the debt from day one as a cosigner, as if you were the primary borrower, right? So there's no real distinction there. Further, it's not implied that you have recourse against the primary borrower in case they default. You would have to have a separate agreement for that. And what I mean by that is that let's say you co-signed a loan for your brother to buy a car. He defaults, they repossess the car, and then they come after you for the deficiency of $8,000, and you pay that $8,000 deficiency. Well, in most states, the law doesn't assume that you can now go sue your brother for $8,000 because you were a co-borrower, an equal borrower on that car, and typically you need a separate signed agreement to create that liability to have recourse against the primary borrower. So that's a cosigner, okay? And most loans in the consumer world are going to be cosigned. A guarantor, the key factor there is their liability on the loan doesn't trigger until the primary borrower defaults. So there we don't have joint and several liability from day one of the loan. So a guarantor is what it sounds like. They are backup for the loan in case the primary borrower defaults. All right, so with a guarantor, again, the liability for the guarantor is only triggered if the borrower defaults. But by that, so that means the loan isn't on their credit report, and they're just in the background as extra security for the bank. You don't really see guarantors that much in consumer contracts. That's really much more a feature in commercial and business agreements. You know, you may have, say, an angel investor who's investing in a company, and they may guarantee some loans for the company or for the entrepreneur or whatever to sort of get things going and so forth. But, you know, they get something in return. They're getting an equity stake in the company. They may get security in some other assets. So, I mean, there's a whole sort of business around loan guarantees, certainly on the commercial side and the business side, that you don't see too much on the commercial side. But the other key thing about being a guarantor is usually the guarantee agreement's going to have some provision that allows the guarantor to pursue the primary borrower for recourse in the event of default. So there, if you're a guarantor, you might then get recourse against the primary borrower for their default. So again, in that situation where, let's say, you guaranteed a loan for XYZ company defaults, you know, you might have recourse to sue XYZ company for the damages you incurred being the loan guarantor. But that type of guarantee, loan guarantees have to be in writing, okay? And that's true in most states. So that's the difference between a cosigner and a guarantor. Again, in most consumer contracts, if you're cosigning, like for a car, for a house, for a credit card or whatever, you're going to be, or for a student loan, you're going to be a cosigner, not a guarantor. Guarantees are more common in the business realm, in the commercial realm. But again, that's the difference. I hope this helped. My name is Matt Burkus, Colorado-based bankruptcy and student loan relief attorney. Have a great day.